It's a great honor for me to participate in this conference and my great privilege. Thank you very much for inviting me, and thank you for your huge effort with us professors who write letters, emails in some strange time and ask strange questions. Sometimes we don't understand our contractual obligations, but thank you very much for your understanding. I'm also very satisfied that I have a chance to participate in this project, because although we teach family law, sometimes we tend to forget some core values. So it's a good opportunity, because when we give lecture, we also learn and ask ourselves what we are teaching about, what is the core meaning of our family law institutes, what is the sense of these institutes. We have another, not just positive content, but also theological, the core content of this and meaning of these institutes and how they are regulated. So I have a quite understandable lecture about procedural rights, but when I chose it, thank you, that was because of Professor Barzo, because you told me last time that you intend to introduce some representation of children in family law proceedings. So I had a collegial wish to share our experience. And I think this might be very useful for you as well. Although, as I found out before this presentation, that Croatia ratified European Convention on the Exercise of Children's Rights, and for example, Hungary, Slovakia, I think also Czech Republic has not, Serbia did not ratify it, and I think it is not so bad as it seems to be. I think also you had, in Slovenia, you ratified, and you had also, we talked about this. So, okay. No, I have presented. Great, thank you. So, this is fine. Okay, let's go back. So, when we start to talk about this, each country ratified a convention on the rights of the child, and there is Article 12, the right of the child to be heard. And in this widely accepted convention is also a provision that the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceeding affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. And in 2009, there was a general comment on the right of the child to be heard, and this quite a general provision has been more specified as it used to be. We also sign and ratify quite general requests, and then later it becomes something else. This is also the right of the child to participate in all, not only in proceedings, but in everyday life as well, in school. And I always ask our professors, have you asked the children, pupils, if they want table tennis in your courtyard, or you want to have a place for football, for example? Because our children were quite disappointed when they found a table, ping pong table, because they wanted to play football in this place. So but it's not legal matter, it's something else. Also, in Council of Europe has quite activity on the procedural rights of the child. First, this is European Convention for the Protection of Human Rights and Fundamental Freedoms under Article 6. It is always it is always the question if the child nowadays had chance to express their views or to have a special representative, especially if the state has ratified the Convention on the Exercise of the Right of the Child. So it's another burden for the organization of procedures in a particular state. And there is also these quite specific European conventions on the exercise of the children's rights, 1996. We proudly signed and ratified this convention and declared that 4 categories of family cases when before judicial authority to which the convention is to apply: parental responsibility as a part of divorce proceedings, exercise of parental care, then measures for protection of personal rights and interests of the child, adoption, and guardianship of minors. And we thought everything is going to be okay because we have social welfare office who participate in court proceedings and also gives a child the chance to express his or her opinion and refers this opinion to the court. So we thought we are fine with this convention, but we are not, in fact. So we changed the law. And also there are guidelines on the Committee of Ministers of the Council of Europe on child-friendly justice. And from my opinion, don't have enough time. It is mostly aimed more for criminal law procedure, not for our civil law procedure, because but it is not so pointed out in this child-friendly justice guidelines. Also, there is European Union has child-friendly justice key agenda for the European Europe. They invest a lot of money. They have many projects. I also took part in one project financed by Fundamental Rights Agency, and in research where we also took part from 2017. These are all key questions. They should be considered and that are requested for each state that wants to introduce really child-friendly justice. And we see these underlined requests and suggestions. That means introducing specialized courts, panels, or judges for children. We do this slowly, very slowly, change of justice system toward family law courts. We'll see how that will work, because there are some obstacles. Judges don't want to be family law judges because they have less chance to be promoted to county courts, and because they are too specialized. Then using child-friendly facilities, that means that each court has to have special place for children where they might be heard, and also some other professionals, making free legal aid. So at the end, you can read this, training of professionals. At the end, this is availability of resources, and it is also very costly. Of course, we don't have enough money. We like to say, let's go to the reform. We are very optimistic, but you'll see what has happened. In historical view is that we had some kind of child participation, especially through social welfare office. But it was concluded that there is a confusion of roles of social welfare office and duties, because social welfare office might initiate the court proceedings, take part in these court proceedings as a party or as a special representative of the child, and has a role to help court to establish facts. So it's total confusion. And also in one of cases, our constitutional court, but after our reform, found out that in a case that started previous, that is not constitutional because it is the breach of the procedural rights of the child, but interesting, not of parents. And what has happened in 2014 and in 2015, Parents and children guardians are obliged to respect the child. Was a reform of our legislation with the basic principles that parents and children's guardians are obliged to respect the child's view in accordance with their age and maturity. General request, rewritten from international documents. But then, in all proceedings affecting any right or interest of the child has the right to find out in an appropriate way about relevant circumstances of the case. This is European Convention. Get advice, express his or her views, and obtain information on the possible consequences of the respect for their opinion. So these requests are introduced from the Convention on the exercise of the child's of the rights of the child. The child shall be heard in accordance with their age and maturity. That means there is no minimum age of the child. And when we talk to our students and they ask how can you get the opinion or view of a small child at the age of 3 or 4 by drawing pictures, psychologists know how to find out how child feels, maybe not things in an adult way, but has some feelings and attitudes and maybe idea what might be good for him. This is very important because that was a huge mistake of the Act of 2014. It was a provision that the child should be heard. But this might be against the best interests of the child, because you can't force the child to express his or her opinion. You may make a conversation to child as a sort of fact-finding, but you can't force the child to say, for example, with whom he would rather live in case of divorce proceedings. This might be quite not so good idea. So it was in 2015. It was changed because that was also one of we had a special story about the Family Act. So and very strong opponents to the Family Act that is now on like a positive source. So the Family Act also has very specific procedural provision. One is that, quite interesting, that the child has the status of party in all family proceedings. It looks very nice, but if you have divorcing parents and one of them wants to get divorced, and they also maybe quarrel about parental care, parental responsibilities. Also, judges do not know how to introduce a child as a party in the proceedings. And some judges, in fact, do this, and some judges don't do this. So what to write? What are the parties? Very simple question. What side will have the child? Active or passive? How to position them? We have no answers for this. So some judges just get over and don't write, don't mention the child as a party, and some judges do this. Why? Because the child has his special representative, and they don't know on which side it should be placed. If they placed, sometimes they might prejudice what at the end will be, what will be the income of the procedure. So our children have the right to directly and indirectly express his or her views, their views in all extrajudicial and judicial family proceedings, and with a special guardian whose duties are clearly prescribed by the law. How we are going to see. And Constitutional Court took very seriously into account if the child has possibility to express his or her views. And as a result, mostly they conclude the child has not this right. And also there is another procedural problem, because usually parents initiate constitutional court procedure, but and this parent sometimes has not right to represent the child. So they say, and they argue that the child's right has been violated, but they are not the representatives, legal representatives of this child, and they can't force the other parent or by social welfare office to have a child as a co-party in this constitutional court proceeding. So there is quite interesting procedural situation. And also Constitutional Court took into account the fact when they found that they found out, but not as a third court instance, that the child has been manipulated, because they said the child did not have possibility to form his or her view freely. So he was under influence of the other parent. So these are all proceedings when the child has to have a special guardian. You may read them in all proceedings, and each time when there is a conflict between parents and the child, on where the parents represent both children at once. So it's also made raised so many questions, because if you have an inheritance procedure and the child has to inherit some property, and there is a legal inheritance, though not by wills. So mostly judges requested that social welfare office appoint a special guardian for these children, or notaries, or in some other cases, for example, when a child wanted to register a car that was inherited. And you need to have a special guardian for this. This is nonsense, in fact. Who is a special guardian? A person who works at the Special Guardianship Center, a lawyer with a bar exam. It has so many duties: to represent the child in the procedure for which it is appointed, to talk to child before procedure, to inform the child about the subject, the course, and outcome of a dispute in a manner appropriate to the child's age. If necessary, contact the parent or other persons close to children. So it means that at least he should contact at least 3 or 4 times a child. It is too burdening. It has also no sense, because you'll see there is not enough time for such a project, I would say. And there are some exceptions for children who are stateless or foreign citizens, migrant children, unaccompanied migrant children, and if a child is 14 years old and the court gives him ability to appoint the representative, it is very, very rare situation, then this representative represents the child. It's a special situation. And also these lawyers with bar exam represent adults with disabilities in all procedures in depriving of legal disability. So it was the question, what should be the skills of such lawyers? And this is very low demanding. They need to be lawyers, they need to have bar exam, and they need to have from 2019 15 hours of education about professional knowledge. That is nothing. 15 hours, this is 3 weeks, that is 3 days, in fact, of education. We will have 8 hours of education here. How many of them are? So in four city centers, in 2020, totally we had 19 lawyers who had to deal with 3,638 cases of special guardianship for children, plus guardianship for adults. The figure is doubled. So it is impossible. And some of them are placed in, centered in Zagreb and need to go 150 kilometers around. They don't have enough cars, they don't have enough skills, they don't have enough times. So it's a Potemkin's village, in fact. So we have unwanted consequences, of course. The bite is too big. We did reform, but we can't, it's not sustainable like this, to say in modern words. The reform had, in fact, as a consequence, the breach of children's rights, procedural rights, because if you give them rights and then deny them, because in only 16% of cases, as our ombudsperson said, had chance to participate in court hearings. That means in the 84%, they breached the law. So what is the sense of these provisions? So it is frustrating for special guardians. It is, in fact, a slap to the face of justice, because you give something and then you say, we don't care for this. The state doesn't try to do this. And also it has a negative consequence that parents are somehow forced to conclude divorce agreement because they don't want to explore their children to, they think, unnecessary talks with somebody who is a lawyer, who has no psychological knowledge, and the outcome of these talks are completely unknown and unpredictable. So I would like to be proud of some improvements of our legislation, but when I heard what you plan to do in Hungary, I just wanted to share our experience and not to make same mistakes. So thank you very much for 3.5 more minutes. I appreciate this and hope to continue with these discussions.